Hello, everyone. My name is Elan Mendel, and if you're in this webinar, you come to see an update on the Crown Forex saga. Before we begin, I'll give you an idea of who I am so that you can understand who is presenting. My name is Elan Mendel. I'm an associate with the Shipkevich Law Firm, which is a New York law firm that specializes in foreign exchange transactions and other events in the futures and derivatives industry. I practice in the capital markets and foreign exchange group within Shipkevich Law Firm. And before I joined the firm, I was with a boutique bankruptcy and insurance coverage group also in New York City, where I represented bankruptcy trustees and attempted to collect money for bankruptcy estates. This is why this topic is particularly interesting for me, since it intersects with the Forex industry and my bankruptcy experience. If anyone has any questions throughout the webinar, please feel free to shoot it over to me, and I'll try to answer it as best as I can. Before I continue, I'd like to point out that while I am an attorney licensed in New York, the information that I'm providing today is not legal advice, nor should it be construed to be any legal opinion. It's only for information purposes only. If you plan on relying on this information and acting on this information, I highly recommend that you see your own attorney first. So let's begin. Before we can get started, let's talk about a little bit of history, how we got to where Crown Forex is today. For those that haven't been following the story in the news, there are two parallel issues in the Crown Forex saga, as I'll call it. There's the U.S. Crown Forex LLC, which was really a Ponzi scheme that was set up by Trevor Cook and Pat Kiley that fell apart in 2009. The Crown Forex LLC company was an unlicensed organization in Minnesota. It was never registered with any state in the United States, and its only assets were one bank account in Associated Bank in Minnesota. On the other hand, we have Crown Forex SA, which many people can remember was a Swiss Forex broker-dealer. It operated for a while offering 1 pip spreads, and that was its big claim to fame until the laws in Switzerland changed when the regulator was changed to FINMA, and FINMA passed some rules that Forex dealers had to have a banking license in Switzerland. Crown Forex SA did not have a banking license, and so FINMA started an investigation, which then led to a liquidation and bankruptcy proceeding, because it turned out that not only did Crown Forex not have a banking license, but the company was also undercapitalized. The principals of the company couldn't account for all investor money that was supposed to be on its books. So that's one of the issues that we're facing today, is the fact that the U.S. Ponzi scheme may not be the only fraudulent activity that Crown Forex SA was involved in. If they were missing investor money, there might be something else going on there. So first, let's look at the U.S. company. The two main perpetrators of the fraud, Cook and Kiley, operated this scheme from about 2006 to 2009. In total, they collected about $190 million from over 900 investors. Now, the scheme didn't involve Crown Forex SA until about 2008, when they started recruiting investors claiming that they were going to send their money to Crown Forex SA in segregated accounts for investment in foreign currency. Now, they collected about $80 million for Crown Forex SA. They purported to be an introducing broker of sorts, but were not registered in the U.S. or in Switzerland as such. So they collected $80 million, but this money never made it to Crown Forex SA. The money that was deposited into the LLC bank account in the U.S. stayed in the U.S. There was some funds that was not deposited in the U.S., about $30 million that was actually sent to Crown Forex SA. So of all the money, the $190 million that was collected by Cook and Kiley, just exactly where did the money go? If we look at the public records of the CFTC and SEC complaints in the Minnesota cases, we can see that $108 million was placed in trading accounts in various companies. So $23 million went to Crown Forex SA, $23 million went to JDFX in Switzerland, $46 million went to PFG Best in the United States, and a number of other companies also received money. The issue was that even though Cook and Kiley told investors that they were going to be putting their money in segregated accounts in the investors' names, what they actually did was pooled all the investor money together and deposited those funds in accounts named in the companies that Cook and Kiley operated. Of all this money, the $108 million that was placed in these trading accounts, $48 million was lost in the Forex market. The other $108 million, not all of it has been accounted for, but the receiver in the U.S. case is actively seeking to reclaim those funds. Now, $51 million was also used to repay investors, so-called Ponzi dividends, those investors that knew Cook and Kiley or were somehow preferred by them, who were cashed out before the scheme fell apart, received a $51 million premium that other investors did not. There was also $12.7 million used to purchase land and develop a casino and some other property in Panama. I know from reading the public records that the receiver is also looking to recoup some of that money from Panama and is seeking to assert claims against entities and individuals in Panama. $10 million was used to purchase a 35% equity stake in JDFX Holdings in Switzerland. And also $3 million was used to purchase a 51% equity stake in Crown Forex SA. This was one of the more interesting things that I've read in the public records, in that, so all this money was collected to invest in Crown Forex SA for investors. Cook misappropriated $3 million of this sum to use to buy his own stake in the company. Now, this happened in around November 2008, which was a month or two before the Swiss authorities declared an investigation and sent the company Crown Forex SA into bankruptcy. The conclusion that is readily apparent when you look at these records is that this money was being used to keep Crown Forex afloat, and whether or not Cook was involved in Crown Forex SA from the beginning, he certainly played a role in keeping Crown Forex afloat when it was undercapitalized. This was important for Cook for a number of reasons. Primarily, if the company Crown Forex SA went under, his scheme would probably be a lot harder to keep going. In fact, many people think that it was because Crown Forex SA went bankrupt that the Ponzi scheme fell apart. Some other money that was used was he bought a mansion in Minnesota. $2.7 million was withdrawn as cash, and a couple $1 million was also used to pay personal debts that Cook owned on his credit cards and gambling debts as well. So if we look at the Swiss company, Crown Forex SA, it was initially owned by Ibrahim Hassanin, and in November 2008, Cook used $3 million to buy a majority stake in the company, effectively owning the company at that point. About a month later, FINMA launched an investigation and placed the company into a receivership, which later turned into a liquidation bankruptcy proceeding in 2009. The reasons that FINMA declared the firm bankrupt was failing to account for client funds, and also failing to obtain a Swiss banking license, which, because of the law change at that time, was required of all foreign exchange broker-dealers. So in speaking with the SEC, I actually placed a call to SEC attorneys a few weeks ago. Their investigation leads us to believe that all the money that flowed at this time went from Trevor Cook in the U.S. to Crown Forex SA in Switzerland. There is no evidence that money went from Crown Forex SA back to Trevor Cook in the States. What this means is that most likely those investors that invested in Crown Forex directly and not through Trevor Cook, their assets are most likely not in the U.S. They have stayed in Switzerland and are part of the bankruptcy proceeding that is currently still going in Switzerland. Those that invested with Trevor Cook, their assets are probably split between the assets that are located in the U.S. and those that are part of the bankruptcy proceeding in the Crown Forex SA bankruptcy. So if we take a look at the recovery process that are going on in both the U.S. and in Switzerland, there are two parallel proceedings going on. The CFTC and the SEC both filed lawsuits against Cook, against Kiley, against all the various companies that they operated, as well as many people who received assets from the Ponzi scheme, Cook's in-laws, and other investors who recovered interest when other investors lost the principal. In these cases, the federal court in Minnesota has appointed a receiver to collect all the assets that might be returned to investors and to prosecute any claims against anyone who might be holding assets that belong to the receivership. Once all these assets are gathered together and liquidated, the receiver will make a report to the court. The court will determine how much will be distributed to investors, and the receiver will be directed to distribute those funds to investors directly. The way that the money will be dispersed will be according to approved claims. Investors that lost money through Trevor Cook's scheme were directed by the court to file claims with the receivership. Unfortunately, that as I'll discuss in a few minutes, that deadline passed on January 14th, 2011, and there's no provision for late claims to be submitted in that suit. But I will get back to that. Now, if we look at the Swiss proceedings, my office has been in touch with the liquidators in Switzerland this week to try to figure out exactly what the current status of the proceeding is. It turns out the bankruptcy liquidation process is still ongoing, and they're still reviewing the claims that have been submitted in that case. From our discussions with the liquidators, this process is going to take a very long time. They don't foresee it coming to a close in the near future, but at the same time, both FINMA and the receivers are keeping the proceedings highly confidential and will not disclose any information regarding the amounts that have been collected or any potential distribution to us. So now that we have that understanding of what has happened so far, let's move to what the current state of affairs is today. So the receiver is actively looking for more funds to add to the receivership. To do this, the receiver is investigating potential sources of assets and is suing those people that are holding assets that belong to the receivership. Most recently, those that have been following the news probably saw a new lawsuit filed by the SEC against Jason Beckman and his wife, Holly Beckman, for their involvement in the Ponzi scheme. And they're pretty much alleging the same issues that were alleged against Trevor Cook when his case came up. Also recently, a man by the name of John Greco was indicted for holding assets for Trevor Cook. There was about $150,000 in assets in a locker in the Mall of America in Minnesota. Also, the U.S. receivership has a $66 million claim in the Swiss bankruptcy that it expects to get some sort of dividend on. Whether the receivership will receive any money on that $66 million claim is up to the Swiss bankruptcy liquidators. We're still looking for an answer from them as to how much money will be paid out. There's also a $1 million bank account in UBS in Switzerland that is currently being frozen by the Swiss government, so we're not exactly sure what will happen there, but I will try to keep everyone posted. There's also claims against companies in Panama, a company called Mesa Holdings, and an investor named Ed Baker. They're also seeking to claw back funds from other investors, which is something that I will get to in a second as well. Currently, the receivership has collected about $9 million in cash and has spent roughly $3 million in the process. In the short term, it has released $2.6 million to investors that have already submitted claims as an interim distribution, and will probably be sending out a check for more money once the receivership comes to a close. Again, the deadline for submitting claims to the receivership was on January 14th, and the court has not given any provisions for filing any late claims in the receivership. In the Swiss proceedings, again, they're extremely confidential. The Swiss government and the receivers are not giving out any information other than general information regarding the proceedings. The deadline to file a claim in the bankruptcy was set for June 30th, 2009, but as I'll discuss in a second, that might not be the case with after my discussions with the bankruptcy liquidators. Once the review process is complete, the liquidators will create a plan for distribution. That plan will be publicly available for inspection by creditors, and then the money will be distributed according to the plan after any objections have been dealt with. So I guess the question now is, Crown Forex owes money. As a creditor, how do we get that money back? So there are a number of options that creditors can consider, and none of these options are foolproof. They can be very expensive to pursue, and there's no guarantee that any money will be recovered based on these options. So the cheapest and easiest thing to do is to file a claim in the Swiss bankruptcy and the U.S. receivership. Again, I mentioned that I spoke with the Swiss liquidators earlier this week, and in my discussions with the Swiss liquidators, they mentioned that even though the deadline passed in 2009 to file a claim in the bankruptcy, that deadline is not set in stone because they're still reviewing claims. And while they're reviewing claims, they will accept any additional claims the creditors might have. In order to file a claim, you have to send a letter to the Swiss liquidators detailing any account numbers, any contracts that you might have, and also giving your contact information in case they need to follow up with you. The process once they receive a claim is such that they will evaluate the claim and send a letter back if they have an objection, which you can then resolve with them, or you can seek a court order setting your claim amount at an amount that you think it should be paid out at. This is probably the cheapest way to go because all it entails is writing a letter, whereas some of the other options that I'm about to discuss involve court interaction and could get pretty expensive. The claim in the U.S. receivership is another option that is not as easy as filing a claim in the Swiss bankruptcy, since the bar date has already passed in the U.S. receivership in January. So what would be required is getting a court order from the Minnesota federal court giving a creditor permission to file a late claim. In order to do that, a creditor would most likely have to enlist the services of an attorney who is admitted in the Minnesota courts and who can file this request for them. While this could get somewhat pricey, it's not as pricey as some of the other methods that I'm about to discuss. But again, the risk-reward ratio is also lower, because we know that in the bankruptcy and the receiverships, there's a fixed amount of assets that will be available for distribution. The receiver and the liquidators will be entitled to fees and expenses before creditors are paid. And so that pool of money might be very small and will be shared with about 900 other investors once a distribution is made. Another option is making a claim directly against the owners and directors of Crown Forex. The issue here is that since the owners and directors allowed the company to become undercapitalized at a time when the investor funds should have been segregated from operating funds, that misappropriation could open up the owners and directors of Crown Forex to liability. The hard part there is finding assets that could be seized in order to pay back investors, which is usually the most difficult part in collections actions. If anyone has any leads regarding where assets might have been hidden or any other information that could be useful in getting a collection out of the officers, directors, or other people involved in the Crown Forex issue, pass that information along, and we'll see if we can try to make the odds of recovery a little bit higher. The third option for getting money back is what's called a clawback or fraudulent conveyance action. In these actions, the purpose is to sue anyone who unfairly benefited from the scheme, whether this is the officers and directors of Crown Forex or other investors who knew about the fraud and received interest on their payments, or family members or other insiders of the companies that received a benefit that other investors did not receive. These actions are, depending on where the lawsuit is filed, it could be somewhat easier to win than in other places. The bigger issue is that there is a deadline to file these types of actions that range somewhere between 2 to 6 years after you learn about the facts that allow you to bring this lawsuit. The other issue is that these actions cannot be brought in the U.S. Because there's a stay that was put in by the federal court in the receivership that prevents anyone from enforcing claims that belong to the receivership. This means that while you cannot bring a lawsuit that the receivership could bring, you are still allowed to enforce any claims that are personal to you that aren't shared with other investors against any third parties, any claims that the receiver would not be allowed to bring. And this is something that if you're interested in pursuing these types of claims or think that you have a claim such as this to bring, it's something to discuss with an attorney to discuss whether or not you can bring this in the U.S. So those really are the three options that are still available for investors and other creditors to try to get some of their money back from the Crown Forex debacle. You can file a claim in the proceedings that are currently pending in Switzerland and in Minnesota. You can file a claim against the owners and directors of Crown Forex, most likely in Switzerland or in Jordan if that's where they currently are. And our firm could certainly coordinate any actions that creditors would like to bring. And the third is to file a fraudulent conveyance action against other investors and other people that benefited from the fraud. And this would be brought wherever the transaction occurred or wherever those defendants currently reside. In sum, our firm is available for answering any other questions that creditors might have. This was necessarily a general overview of what the options are, and the information that I gave today really isn't useful without knowing your personal circumstances. So I highly encourage anyone who is seeking to recover some of their assets from Crown Forex to discuss their alternatives with an attorney who can tailor this advice, their advice to your personal situation. If there are any general questions right now, I am happy to answer any of those questions. Otherwise, feel free to contact us via the contact information on the screen. All right, since there aren't any questions, I guess we can conclude the webinar for today. Okay, so there's a question that just came in from Boyke. Why are U.S. funds not segregated? The answer to your question is that U.S. funds are supposed to be segregated. The fact that they weren't segregated in this case is just a matter of the fact that this was a fraudulent situation and wasn't according to U.S. law. The funds were supposed to be segregated in the Swiss company as well, and that's just not the way that the company is operated. The question is, how were they able to get around that? They weren't. The only issue was that there was a lag in the amount of time that FINMA was able to step in and close the shop down. Eventually, the reason that the company was put into bankruptcy is because those funds went missing. And Boyke, I'm sort of confused by your statement. In the U.S., all Forex brokers have to keep their funds segregated from customer funds. That's an NFA rule that all brokers have to abide by. If you would like to discuss it, we can discuss segregation issues off the webinar, but you're never allowed to commingle in the U.S. Company funds with investor funds. Any firm that is registered with the NFA in the U.S. has to keep their funds segregated from investor funds. So that is something that is done by all registered firms. You're welcome. Any other questions? Boyke, I'm not familiar with REFCO. What is the question? Story. The segregated funds in bankruptcy are a sticky issue. At least speaking for the U.S. bankruptcy proceedings, since I'm an attorney licensed in the U.S., only funds that are held by registered securities dealers have priority in bankruptcy. So even though all these firms do have segregated funds, those funds don't necessarily enjoy a priority scheme if the company goes bankrupt. What that means is that the funds aren't commingled with the company's assets, but they still might be tied up in a bankruptcy proceeding before investors will get their money back. The segregation allows regulators to be able to see on their books that companies are keeping investor funds at the same level that they're supposed to be at and that they're not dipping into those funds. Now, I also received a question asking whether it's possible for a forex broker to go bankrupt. And yes, it's possible for any company to go bankrupt at any point if they're not able to make their debt payments whenever their debt payments are due. Different jurisdictions have different protections in place for creditors and other investors in the case of a bankruptcy. And so it really depends on where the broker that you're using is located as to what kind of protection you'll receive as an investor if your broker goes bankrupt. To elaborate a little bit more, if you're looking at the Swiss bankruptcy in Crown Forex, the creditors in that case, the investors, don't have any priority. Their claims against the assets of Crown Forex are lumped in with all other creditors, whether it's the people they bought their paper from, or a janitor company that they used, or any other trade creditor that they might have had. All those claims get lumped in with investor claims. The only priority that is given to claims in the Swiss bankruptcy is for employees, so that they can receive their salary for, I believe it's 6 months, before other creditors get their money back. And different countries and other jurisdictions have different rules regarding priorities of creditors. So it really depends on where the bankruptcy is taking place. Thanks everyone for coming to see this webinar. I hope you all enjoyed the information that was provided. If you have any other questions, please feel free to contact FX Street or me, and we'll try to get you the answers that you're looking for.